before we commence, because it can be distracting if someone's microphone is on, then I have to stop and start over again. I notice we are about 76 on the platform now. Last night we were well over 200, so the others will probably join as soon as they've established their connections. All right. Now, last night we dealt with a few interesting topics all the way up to jurisdiction for today. And today we are going to continue with jurisdiction, and we are going to start with the requirements in terms of Section 28 of the Magistrates Courts Act. Now, one of the things that we said last night was that when one wants to establish jurisdiction of a court, one of the things that you need to look at, so it's not a be all and end all, you need to consider the person whom you are suing or you wish to sue. And persons refers to both natural persons as well as juristic persons. Now, the person, it's important to know the person in respect of whom the court shall have the jurisdiction. And in terms of Section 28, more particularly subsection 1, capital A, the court shall have jurisdiction over the following persons. Firstly, any person who resides, carries on business, or is employed within the district or regional division. So we are referring to both the district and the regional divisions of the Magistrates Court here. The second person over whom the court will have jurisdiction will be any partnership which has business premises which are situated, or a member of such a partnership who resides within the district or the regional division. The next person in respect of whom the court may have jurisdiction is any person, whatever, in respect of any proceedings which are incidental to any action or proceeding which is instituted in the court by such a person himself or herself. The next person is any person, whether or not he or she resides, carries on business, or is employed within the district or the regional division, if the cause of action arose wholly within that district or regional division. Remember last night we said the accident took place in a specific place, or the contract was concluded in one place and the parties both reside, the other parties both reside in different jurisdictions. One may rely on where the cause of action arose. The next one then we said that is a person or any party to interpleader proceedings. If one, the execution creditor and every claimant to the subject matter of the proceedings reside, carry on business, or are employed within the district or the regional division. Now we will deal with interpleader proceedings at a later stage where I will explain what exactly it means. But for purposes of today, just know that when it comes to the issue of jurisdiction in the Magistrates Court, be it regional or district court, the following applies in respect of interpleader proceedings. We've already said the execution creditor and every claimant to the subject matter who resides, carries on business, or is employed within the district or regional division. The second one in respect of interpleader proceedings is the subject matter of the proceedings has been attached by process of the court. So the particular court that has attached the process, because interpleader proceedings have to do with the right to claim property which has been attached by the sheriff. So if the sheriff has already attached in terms of a court order or a judgment issued by a particular court, then jurisdiction will have been established in respect of the person, right? Or the subject matter. Next, in terms of interpleader proceedings is if such proceedings are taken under section 69, subsection 2, and the person there is referred to as the third party either resides, carries on business, or is employed within its district or regional division. And if you remember, last night I told you that you need to have the rules as well as the act so that you can refer to the act whenever you need to. So section 69, we always keep our books with us. Section 69 refers to interpleader claims. So interpleader proceedings you will find under section 69. And the last one under interpleader proceedings is where all the parties consent to the jurisdiction of the court in interpleader proceedings. If one party to interpleader proceedings does not consent to the jurisdiction of the court, then jurisdiction will not have been established in respect of that court. Right. Another person in respect of whom the court shall have jurisdiction is any defendant, whether in convention or reconvention. Now we'll get to convention and reconvention as well. Convention is a main action, and reconvention is a counterclaim to that action. We will deal with it in more detail later. And there, in those instances, it's any defendant who appears and takes no objection to the jurisdiction of the court. So where a defendant has accepted that he or she is being sued out of that court and does not raise an objection to the jurisdiction of the court, it will be implied that that person, it will be inferred that that defendant has by implication agreed to the jurisdiction of that court. Any person who owns immovable property within the district of the regional division in actions in respect of that same property or in respect of mortgage bonds thereon.
Colleagues, what is happening? Are we still on the call or what?
Yes, it seems like Mr. Pitt is just struggling with the connection.
Oh, yeah.
Oh, okay.
Wondering.
So I thought it was just me. Yeah, I think it's network. Let me talk to him.
My
I'll
apology.
call him just.
I don't know what
network.
happened. I'm back. My apology. Let's blame it on ESCOM. I was kicked out. I'm sorry. So again, Ray, Nana can suggest that I switch off the camera. Okay. Henry does not want to see my face, all right? Okay, we'll proceed then faceless. So you need to familiarize yourself with the provisions relating to section 28 in respect of jurisdiction in terms of persons. Now, one important thing that you must remember is when you are referring to persons, you are also referring to the state. Remember, we said it's not just natural persons. No, again, I don't get angry very easily. It's fine. So the state is referred to as a person. It's not just a natural person, but a juristic person also includes the state. And it's a very important person because the state is responsible for a big percentage of litigation, including litigation in both the regional as well as the district magistrates' courts. So you need to familiarize yourself with the various cases involving the state. Right. You need to know what it means to reside within the jurisdiction of the court. Residing within the jurisdiction of the court does not mean that you are here over a weekend, something happens to you, and then then you are gone after that. And then when you are involved in something, let's say an accident outside of the jurisdiction of that court, you want to now allege that you reside outside of the jurisdiction of that court or within that jurisdiction of the court. You must ordinarily reside within the area jurisdiction of that court and not be there on a temporary basis. You have to be there on a full-time basis. All right. The same applies to carrying on business. Carrying on business does not mean that you were driving through a certain town or a city on a specific day when the incident occurred, and therefore you were carrying on business because you were on your way to your offices. You have to actually have an established address at which you carry on business within that district or that region. You will see that in your notes, there are references to many, many cases. Now, and an example I will make for you now is the one in Minister of Law and Order versus Patterson, which is a 1984, volume 2, South African Law Reports, page 739. And it was an appellate division case, as you can see by the capital A in brackets. I'm now reading on page 47 of the notes. And the particular paragraph which is important in this judgment is found at pages 752, paragraph A to paragraph C. And in that particular judgment, the phrase or portion that is important that relates to jurisdiction is the following. The residence or place of business of the state is Pretoria, in terms of that judgment, the seat of the government. In terms of section 23 of the 1961 Constitution, it was provided that the seat of government of the Republic was Pretoria. The present Constitution does not have a similar provision. However, Pretoria remains the de facto seat of government of the Republic. On the reasoning of Minister of Law and Order versus Patterson, which is the case we are reading now, every government or statutory body or quasi-statutory body may be said to reside at the place where its headquarters or principal place of administration is located. So there you see a discussion on what was decided in the case of Minister of Law and Order versus Patterson. And the citation is given to you there as well. When you are referring to case law or a judgment, which is another word, another usage for it, you must quote the entire, cite the judgment fully, as is done there, together with the year in which the law report was published, the volume of that year where you will find it, and you will see that it's South African Law Reports at page 739, and in brackets, the capital A suggests that it was heard in the appellate division at page 752, A to C. Now, the fact that it was heard in the appellate division should tell you that this case was heard in what was then called the Supreme Court before the appellate division. The Supreme Court is now referred to as the High Court of South Africa, and the appellate court is now referred to as the Supreme Court of Appeal. And after the Supreme Court of Appeal, the Constitutional Court is the highest court in our land. You should keep that in mind at all times. And on the following pages, you will see there are references to case law. You should familiarize yourself with those cases. Take nothing for granted. Read them. Lawyers read. That's one of the things that we do. We read. And if you are lazy to read here, you are not going to make a very good lawyer, because everything is contained in the books, the materials that we refer to, the statutes that we refer to, and the judgments that we have to read on a daily basis. Right, now we go to section 30, interdicts. Now, what is an interdict? An interdict is a court order which is granted by a court to either prohibit certain conduct or to compel certain conduct. So it may take the form of a positive interdict. In other words, you are compelled to do something, or a negative interdict where you are asked to refrain from doing something. Now, the magistrate's court may grant against persons and things orders for attachments, interdicts, and mandement van spolie. Mandement van spolie is a Dutch phrase used to describe what is called in English spoliation. In other words, when you've been deprived of the use and enjoyment of something, then it's called spoliation. An attachment of something is when the sheriff writes up property and then produces an inventory to the party who has sent the sheriff to do so on the other party. And that is referred to as an attachment, a legal attachment. Not literally attaching something. It's the symbolic writing up of something, and the sheriff will tell that person, I have now attached these goods. You are not permitted to move or remove these goods under any circumstances. So normally what happens after the attachment of such goods when they've been written up, and it's normally after a period of 30 days in satisfaction of a judgment which was obtained by a judgment creditor against a debtor. Now, because the sheriff has attached, or rather the creditor has attached the goods of the debtor via the sheriff, after a period of 30 days, if the execution debtor has not satisfied the debt owed to the execution creditor, the execution creditor will send the sheriff to go and now physically remove the goods that have been attached for a sale in execution. All right, I think that was fairly straightforward. Our courts are very careful these days not to just grant willy-nilly orders which will necessarily disrupt or interfere with the rights of others, because in our constitution, in terms of section 36, we have the limitations clause. For every right that we claim we have, there is always a corresponding right by the other person, because the relief that is often sought in civil procedure is for the enforcement of the rights of a person against another person. So the courts will always consider the rights of the other person involved before they grant orders which may interfere with the rights of those persons, especially constitutional rights. So an application for the attachment of a person's property, as I've referred to previously, must be made in terms of Rule 55 and must be accompanied by an affidavit which states the full facts upon which that application is made and the nature of that order which is applied for. And the court will only make an order for such an attachment if it is satisfied that the respondent is about to leave the jurisdiction of that court. So in other words, in the affidavit of that application supporting the application for that attachment, you, the applicant, must tell the court, the reason for me applying for this attachment is because the goods that I want to attach belong to a person who is about to leave the jurisdiction with the goods. It may be immovable goods in this case, such as a motor vehicle, furniture, or any other immovable property. Or the court will also, if it is satisfied, make an order, or once it is satisfied that the respondent is endeavoring to dispose of the property in order to evade his creditors. So if it is known that you have property and there is a suspicion that you want to now dispose of that property, in your application, once again for attachment, you as the applicant must make the allegation that the respondent intends to dispose of the property, and therefore I will not have the right, or my right will not be enforced or enforceable to attach the property in satisfaction of the debt which I have, which that person owes me. Then thirdly, the court will grant an order only if it is satisfied that the respondent, or confirmation by the court of an interim attachment of an action, operates in terms of section 30, subsection 2. So if there had already been an order for attachment granted in respect of property, the court may confirm that court order in terms of section 30, subsection 2. Now, section 30, subsection 2 refers to such an interim attachment or an interdict until further execution. by that party or the applicant against the respondent. Now, just to deal briefly with interdicts again. Interdicts, an interdict, as I said, is a judicial process whereby a person is ordered to either refrain from doing a particular act or to perform a particular act. In other words, once again, negative and positive acts. It is an extraordinary remedy and will or may interfere James Mapoto. Is there something that you would like to ask me, sir? James Mapoto?
I suggest we continue.
Pardon?
I suggest we continue.
I'm asking you about the message which you sent on the chat now.
No, it's not James Mapoto speaking. I'm just suggesting that we continue because he's not answering.
I think I am going to ask Zuki to switch off the chat because it's distracting.
Yes.
It is really distracting and it's not taking us anywhere. If anyone is not satisfied with the way in which I'm presenting these sessions, please take it up with Zuki. All right? I'm going to ignore all chats from now on because it's not taking us forward.
And these things are in the book.
Yeah, I don't understand why people want to have private conversations on the chat when they have the notes.
Interdicts is on page 52, guys.
Right, section 4, in terms of section 45 of the Act, parties may consent in writing to the jurisdiction of either the court for the district or the region in order to determine any action or proceedings otherwise beyond its jurisdiction. So both parties must consent to the jurisdiction of the court. It cannot just be one party that consents to it. If the other party does not consent to the jurisdiction of the court, then that court will not have automatic jurisdiction. It will then be up to the other party to prove that the court has jurisdiction. Now, section 45 must be read with sections 46 and 29. Now, section 29 is in respect of causes of action, right? And section 46, rather, it reads as follows. If the parties consent in writing to the jurisdiction, the court has jurisdiction to determine that action or proceedings otherwise beyond the jurisdiction due to the monetary limit. So it's the amount of money that's involved. And remember last night we said the district court has a jurisdiction up to 200,000 rands and the regional court has a jurisdiction from 201,000 rands up to 400,000 rands. So only a court having jurisdiction under section 28 will have jurisdiction. A party may apply to court to transfer a matter to another court, from one court to another court, with the consent of all the parties involved, or upon application to court in cases where it will be more convenient to hear the application in court. And the reasons or convenience may be the parties all reside within the jurisdiction of that court. The witnesses are all based or all reside within the jurisdiction of that court. It will then be convenient for the court, that particular court, to have jurisdiction over those matters. And the magistrate's court shall have no jurisdiction in the following matters. And this is important for you to know at all times, because you're going to have to advise your client accordingly. Firstly, when a matter involves the interpretation of a will, the magistrate's court will not have jurisdiction. In a matter which a status of a person in respect of mental capacity is sought to be affected, in other words, where an application for a curator ad litem or bonus over a person who has mental disease or has brain damage as a result of an accident, the magistrate's court will not have jurisdiction over that person. Also, the magistrate's court will not have jurisdiction in which specific performance in a contract now, without an alternative of payment of damages, is sought. And also, where a decree of perpetual silence is sought, the magistrate's court will not have jurisdiction to hear such a case. All right, on page, I hope my notes are in line with yours. On page 55, there's a diagram of the magistrate's courts. There's a diagram of the magistrate's courts on page 55, where you have the exceptions to the 400,000 Rand general rule. On your left, even if over 400,000 Rand, certain claims may be brought in the magistrate's court if there is consent or...
For us, it's page 58 on the study guide.
All right, thank you.
Sorry, Advocate.
Yes.
Tell us, what is the decree of perpetual silence? Yeah, true. That's perpetual silence.
Maybe you must not refrain from.
What happened, guys?
Perpetual silence.
Hello.
Yes, sorry, I don't know what happened there. Where a party continuously threatens another party with legal action, you may request the court to prevent that person from continuously doing so by obtaining what is called a decree of perpetual silence. In other words, shut up for good. In such cases, the magistrate's court will not have jurisdiction to hear those cases.
Thank you.
You can only obtain such decrees in the High Court. All right. So you'll see then on the next page. Okay, someone is showing us a picture there.
Advocate, can I please ask?
Yes, sir.
Is there any other example where a decree of perpetual silence can be sought, beside that one of somebody threatening to open a case against somebody?
You need not worry too much about that. It hardly ever comes across. I mean, I haven't been practicing for long, but since 1999 until now, I have not come across it at all.
Thank you.
You may read up on your own to enlighten yourself on it.
All right, thanks.
Any further questions? All right, moving along then. In actions where the sum which is being claimed is within the jurisdiction, and that sum being claimed is the balance of an account, the court may make an inquiry into and even take evidence, if necessary, from a witness, even though that account may contain items and transactions which exceed the amount of the jurisdiction. And the test is the amount which is claimed. So if the amount which is claimed falls within the jurisdictional limit of that court, and even though that account falls outside of the jurisdiction of the court in terms of the amount, the court may entertain such a claim. If your entire claim falls outside of the jurisdictional amount of the court, let's say it is 412,000 rands or 480,000 rands, and you want to bring that claim within the limits of the regional court, you may abandon the 80,000 rands to bring that claim within the jurisdictional amount limit of the regional court, which is 400,000 rands. You may not claim the balance of that, the 80,000 rand, you may not claim it in another action, because then you will already have exhausted the cause of action. The High Court, which is higher than the Magistrates Court, enjoys what is called concurrent jurisdiction with the Magistrates Court. So if a matter falls within the jurisdiction of the Magistrates Court, a plaintiff or an applicant may institute proceedings in the High Court as well. So it is up to the party to decide out of which court it wants to institute proceedings, and it wants to establish jurisdiction in respect of that particular matter. If a party wants to object to the jurisdiction of a court, that party must do so by way of a special plea. Jurisdiction, or the objection to jurisdiction, is raised by the defendant as a special plea. In an application, the respondent will raise that point of jurisdiction as a point in limine. It's what's referred to.
I'm sorry, which page, which section we are?
We are on the virtual section now.
Extra section. This page.
Are you not listening to me?
I'm listening, but I'm lost now.
Did you read your notes before today?
No.
Because if you did, you would know where we were. I suggest you listen to me, ma'am, okay? And read during your own spare time, all right?
But sir, I think it's very important for us to know on which page we are. To be honest, we really need to go with you, because we are trying to check we really want to go with you. At least if you can tell us on which page are we, it will be much easier for us.
Because I was in the page, but now I'm lost.
The gentleman who just spoke now, have you read your notes before today?
Is it a prerequisite that we read notes before we come?
Sir, I haven't read the notes today because I've got some other commitments because I was busy the whole day attending some other meetings. So I haven't had chance. So that is why I'm here in this class, because I want to go with you. That is why we are asking on which page we are.
Did you attend class last night?
Yes, I've attended.
And did you hear me say that you should read your notes before?
I heard you.
Yes.
But we are working during the day, so
I'm also working during the day.
Exactly my point.
I am also working during the day.
The reason we took this night course is because we are working during the day. So the lady just asked you a fair question. Will you please give her a fair answer? Let us not be angry to each other.
I agree.
I think it will be fair for us to get a matured answer from you, sir. I'm also lost.
We are on page
Just give us
63.
a page number. Where are we on the study guide? That's all she's asking for.
No, the advocate is very harsh to us as the student. He needed to refrain how he addresses us.
Guys, we're on page 63.
Exactly.
Number, like
63.
But the advocate must lead us, eh? Please, guys. We need a fair choosing, please.
We'll take a short break.
Thank you, advocate. Thank you.
Thank you.
Thank you.
It was going to be
Okay.
easier if we had the slides projected in the screen. I'm also unable to follow.
How long will the short break be? Please advise. Please advise on the duration of the short break, please.
So is this lecture now over?
Oh, what is one?
I think maybe he's on like a break and he's trying to talk to Zukiso or something about how to proceed further.
Hi guys, I just wanted to check what's happening with our lecture, our teacher.
We are on a short
We
break.
are on a break.
Yeah, he said we're on a break. I heard he said he's we taking a
So we
break.
take a break. Yeah.
For
Yeah.
how long? For how
10
long?
minutes, I assume. 10 minutes, I assume.
Yo, but
Yeah,
I'm sensing a bit of rudeness.
Let's
Am I
take
the only one
and
who
see.
sense the fact that he's being rude to us?
I think,
Guys,
honestly, he's
in
saying
class?
that he expects people to read their material before class to at least have an idea on what he is talking about.
He's
But
rude.
we're on night school.
No, I agree. He's
You
totally
have an
We are,
idea.
The
He needs-
problem
okay,
is
can we
that
just
you need to
speak
know
like
where
one
it
person
is.
at a
You
time?
cannot remember that, okay, I did the notes for this, maybe it's in page. You need to a guide to say, okay, now we are at maybe this topic or whatever, or page this. Even if you make notes, you still need to know where the lecture is. It's not about you not reading your material.
And it's a
But
simple
guys,
question. Just answer, tell us which page.
you
Why
know,
does he have to get
But
so
that's why
upset?
we chose this,
sorry,
this
guys.
because we are working.
Guys,
Hello?
guys, please,
Hello?
please, please.
Sorry, guys.
Like,
The advocate
Sorry,
indicates
guys. Hello?
that you
Hello?
will not following the notes in our.
We're all talking at the same time. How is anyone expected
Hello,
to hear each
guys.
other?
Hello, guys. Hello, can I say something? The problem is that our notes and his notes are not following the same pages, it looks like. So that is why there's confusion.
I think the part of the
I,
notes
I
is
think
responsibility.
we should be patient with the lecturer. We have a guide for a purpose. If anybody did not understand, he can refer to his guide. Let's just listen to him and get an idea.
Hello, guys.
Can we not speak over each
hello.
other, sir? Sir,
All right.
can we not speak over each other? Like,
Let us
honestly.
just listen to him, get his understanding about the model in question. You understand? If there is anything that we have as a question, we can ask for clarification.
Yeah, but
Then
he's rude. He's rude. The thing is, he must also listen to our concern.
Hello,
He's
guys. Can
rude
I say
when
something?
answering the
Yes,
questions.
he need to
So
listen because we have paid for this
he needs
training.
also to listen
We
to
have
our
paid,
faults.
really.
Hello.
Sorry, jurist,
Yes.
may I just interrupt? You guys can't let your
Yeah.
emotions lead
Our
you.
concern
You
needs
can't let your
also to be
emotions lead
taken
you.
into consideration because
Hello,
I mean
guys, we
the question
understand
was
that.
very simple.
You can't let
Where
your
are
emotions
we
lead
on
you.
the
Ask the
guide?
questions and raise
Hello,
them
guys.
later
Can I
on.
say something? Why did we
He
have
is
a
not
problem
the first
with other
lecturer to
lectures?
present on us. We never had a problem.
We never have a problem with other lectures, isn't it? We were coping rightly, but now why do we have a problem with this one?
Exactly.
So
Maybe
I
I
think
think
he is
maybe
so
the principal
impatient
of the
with
school
us.
needs to be told of this.
No, everyone
But
is
what
different.
happened?
Yes.
What happened to the WhatsApp group that we were promised of? Because some of these things, I think we should be discussing them there.
Shouldn't we take it up with Zukiswa? Rather?
Yeah.
Yes, we
I think
need
the
it
management of
because he
the
does
school
not
needs to
need
know
to
our
treat us like
concern
kids. We are not
if the
kids.
lectures
We
cannot
are
take note of
adults.
them.
And he told he told us that we must read yesterday. He told us yesterday that we must read, and we are working. When
No,
we
that is not
I-
the problem. Even if we can read,
That's true.
but
We are
if
weak.
you don't understand something, we have to ask. You have to be
But-
patient with us.
But another thing, guys, is if you heard what our advocate said when we started, he said he's not going to go with the study guide. He's going to just give us what is happening in the practice. But I'm surprised he's the one who referred to the page. The first person to refer to the page is the advocate. And then when you look at the page, it's not the page numbers that we have. So I was so confused actually.
We are not at court here. We are in the learning environment. He also needs to understand us. We are here in this platform to learn. He does not need to bring himself, not be open for us to engage him.
and I think he's angry because he told us we are on lunch, but
No. This person
there's
is
no
so
time when he is
impatient.
coming back. He just says we are on lunch.
Guys, let's just be patient and allow him.
He must remove himself. Another presenter must come for the same subject.
I agree.
I also agree.
If he is impatient of us, he must remove himself. The
This course
institution
is
must
costing
look for
us a
another
lot,
person that is going to understand us.
and he needs to
But
understand.
guys,
He
listen.
also seems to be reading from the
Who
guide.
is the principal going to engage now to lecture us? We have to be
Can Zukiso
patient.
come in and assist here, guys?
We have to be patient and allow him to finish his lecture.
I'm listening
to you, and
you
then
are
when you
right. We have to be patient with him, but also he have to be patient with us.
Exactly, and he needs to interact with us as much as we
But
need
guys,
to
this
interact
is
with him.
time wasting. This argument is
We
just time
are
wasting.
at
The
a
lecturer could be
disadvantage
teaching
here.
us.
He is not a
The
student.
lecturer currently not in this class, and if we really have a problem with how things are going here, I really think we should email Zuki. As she's going to receive many of our emails, she will see the seriousness of how to address this issue. Because as we are yelling here, this is going to come off as if we are candidates who do not have ethics, because we are shouting and yelling at each other. So can we honestly conduct ourselves as if we are legal practitioners?
Exactly. I agree 100%.
Yeah.
So why is
And
it that
not
when
just
we have
myself,
to go through
I get that we are not happy. I get that people are unsatisfied with the way things are going. But there is a way in which we can address things. And knowing this profession, there is a professional way, a procedure upon which such can be resolved.
Don't I'm saying, why do you suggest we do in the meantime while we're waiting here?
Thing is, I feel like Mr. Donovan is going to come back and give us, a go ahead. Or maybe Zugiswa, who's probably recording this session, is going to do that. But until then, we ought to just really wait, because he's the person leading this very session.
Okay, we will wait. I agree with you. We will wait and then we will want. But also the way he left us, like you can't just say, let's take a break. He doesn't say till what time, and we understand. Like I agree with the people that say we paid a lot of money. You can't just be left hanging like we are kids.
I understand, but everything happened in the heat of the moment. I think he's also trying to, take things the way it was in that moment in time. So he doesn't want to place himself in a position of saying wrong
But why
things.
is he getting so
Guys,
heated
there was
up
really
about it?
No, but you
Why is he
cannot use our
adopting this
emotion.
draconian
We
approach?
cannot. No,
Why?
no, no,
Guys,
no,
we
no. It's
can't use
wrong.
our
We can't use the
emotions.
emotion here. We are here to learn, not the emotions.
You see that the way people were now just all talking at the same time, they were
Yes.
using emotion,
Yes.
which is what I'm saying. All refrain from and see how he, from a lecturer point of
But
view,
I think he
can we calm down? Honestly, I really think that if we do, he is going to be allowed the space or the platform.
but to be honest,
where
it's him who made this issue to
I guess
he was so rude. He was
we have
so
done. It
rude.
was just to mention the page number, then we move.
we remain calm.
We have established that he was rude. Can
Fellow
we move on and
students.
conduct ourselves in a professional manner?
Fellow
Thank you.
students.
First, can you all just
Fellow
calm down?
students. Can we make suggestions than to be making some disparaging comments? Anyone who speaks, why can't we just maybe be orderly and try to make suggestion as to what should happen, engaging the school management, not amongst ourselves, speaking from in this platform in a disorderly fashion. Maybe let's make suggestions. Maybe those, yes, maybe
I
those
think
that,
we should make suggestion. We
yes.
should report him to the school principal.
Nana, sorry, can I say something? Let me add something. Everybody is different. So you can't say because Mr. E did not treat me the way this man is treating me, I'm not happy. This man is advanced. This man has everything to give us. He is well taught and well read, well advanced. So can we humble ourselves even if he is wrong and get the best out of him? Let us learn how to get the best out of this man. That's
I said,
Okay.
I said
Hello,
before,
hello, hello. This
we
is
are
Iswazi.
we are at a
This is
disadvantage here.
We are students. We are students. Let's learn how to humble ourselves and get the best out of him.
Exactly.
Hello.
No.
We got what we want.
No.
Please.
Guys, this is not the platform.
Yeah.
But then, if you are saying no and no, who do you expect them to give us now?
Fellow colleagues, can I make a proposal? Can I make a proposal?
Yeah, you can.
Can I make a proposal?
Yes, please.
Yes, I would like to propose that anyone who is not happy with the manner in which things have been conducted and follow the processes that are the guidelines of this program and engage with the management privately.
And he said that. So
please,
I suggest
guys,
allow
whatever you
he's
say,
coming
just be
back.
careful.
Okay. Can you all
What if
hear
he's
me?
back on the chat? What if? How are we gonna know?
Hello. This is Zuki.
Let's
So
just be
can you
patient.
all hear me? Hello.
Yes, we are listening, Suki.
Yes, Kiswa, please
can hear
come
you.
assist.
Yes, we can hear you.
Okay. I can hear what you guys are saying, né? But please remember, you guys had options. I know most of you are working, most of you have challenges and everything, but you must just remember that you opted for this program, the UNISA distance learning program, because you want to reduce your period of articles. If you look at the time of our lectures, it's only 3 hours, whereas the full-time school and the night school and day school, it's more, okay? So the lecturers cannot be the same. The instructors cannot present the same. You are not just students, you are candidate attorneys. I mean, the behavior, it's really unacceptable, okay? So I'm going to end this meeting today. So tomorrow, I'm going to sit with Mr. Malima. We are going to listen to the recording again, and then we'll decide whether we end the lectures for all the lectures anyway, because we are still going to have more lectures. So if you do not want to participate in lectures, or you disrespect candidate attorneys, you disrespect your lecturers, I mean, that is not on. This is law school.
Exactly.
There is a way of addressing issues. There are candidates that prepared. I gave you this program when? Last week, was it Friday? I gave you the program on Friday. You know what's going to be covered today. Yesterday, advocate told you that he is not going through, he's not going to go through page by page. Okay, so I don't understand now if you tell him that you are working, you don't have time and all that. Come on.
But
So I'm going
Zukisa,
to
that's
end
not
the
fair. That's not fair. We are willing to listen. We are willing to be here. Zukiswa,
on him.
we are willing. We are here every
I
day,
said
every
this thing
night.
before. Please, everybody should
Zukiswa,
listen.
it's not fair.
Everybody
We
should
are
listen,
here
please.
every day, every
Zukiswa,
night.
I'm wondering,
No,
is there anything wrong if we ask about the page? We just ask, the lady asked, which page are we in? That was supposed to be the answer, to say we are on page 61. Advocate can't tell us, you're supposed to be prepared and all those kind of things. We wanted to know the page number. That was the issue. I don't understand.
I actually want Zugiswa to listen to our previous lectures, how we are interactive and ask questions, which shows that we are willing to be here. We ask questions. We
But I
Zugiswa,
believe
it's
we
not
cannot
fair.
make up
Guys,
for
please,
other
everybody
people's
should listen.
wrongdoing.
Let me make this, let me bring up this idea. We are, as we know, candidate attorneys and or legal practitioners. We are of a standard that we are supposed to know some of these things. However, this lecturer is a bit different, and we should understand the human nature by now. You know, we need to get something from him. He is not the one that wants to get something from us. So we need to be patient to get that which he has to offer. If you are not happy with
I agree with you 100%, and we always ask questions. We always
Exactly.
we are always interactive.
Exactly.
yes, it's not
It's not
every lecturer
fair.
that is
It's
going
not
to
fair on
teach you the
us.
way. Listen, guys, it's not every lecturer that is going to teach you the way the other lecturer taught you. It's not going to happen. There are
Exactly. No
different
one is meant to
kind of
cater to your
people.
emotions or your
You
feelings.
understand?
but-
Some people,
Because this is
But
time
we are
wasting.
with
It's time
the
wasting and it's
attitude.
affecting everyone
guys,
who
guys,
has
guys,
nothing to do with this.
Some people
it's
will
not
come with the
getting
attitude
information.
that you are at this stage of your study and you're supposed to know some of the things that he's teaching you now. So we need to
We are here
listen.
to learn, guys.
Guys, can I say
We
something?
need to listen and be patient and get what he's going to offer. We
Yeah.
cannot sit down
You're
here and start
right.
arguing
You're
with somebody
right.
who's going to
Guys,
lecture us.
Zugisa,
guys,
can I say something?
guys,
Can I say something at least? Okay, guys, let me make this appeal. It appears that the advocate is one of those tough individuals, you know. And then and I also learned that Ausi Zugisa is not taking kind of the comments that are made. Let us strike a balance. Let us say that today, unfortunately enough, we are being taught by somebody who's very tough. You know, let us just listen to him, continue the lecture, you know, and then if he offers, you know, to an opportunity for us to ask any questions, it's fine. If he doesn't, it's also fine, you know. And then in terms of the pages and so on, I don't think that maybe let that be an issue, you know, that is going to actually cause us to get into trouble, you know, because if for instance, you know, we're being labeled as being rude and so on, and I know that we're not like that, you know. So I think that let him continue. We'll just listen, you know, and then us an opportunity for questions is fine. If it doesn't, it's fine. We'll just met somebody who's tough, and then
As attorneys, we are going to experience this type of things, even in practice. We are going to experience different kind of people.
So let us acknowledge that we've got somebody who's got a slightly tough personality, and then and we go on. That is my suggestion, guys. Please.
Guys, can I also say something here, please? Guys, listen here, and I don't want to give the impression that I'm taking sides, but the advocate indicated when we started off that he's not going to follow the our manual, right? I understand the way he answers us. I also have a problem with that. That's the first point. The second point is we have a responsibility as well. We're supposed to be reading. I mean, that's part of our responsibility. That's why we receive the program.
Yes, we can't be
So
spoon-fed.
guys, we shouldn't renege from our responsibility as well. I mean, we need to be fair in this instance.
Absolutely.
Yeah, but
the candidate attorney have gotten to the stage where
We are being fair.
shouldn't
What
be
is wrong
spoon-fed.
about asking questions, and what is wrong about
But there's
us
nothing
saying
wrong asking
that we need?
There's
Yes,
nothing-
what is wrong about saying that we've been
You know,
interactive,
according
we've
to
been
me,
asking questions.
I
There's
I
nothing
did
wrong
not.
with that.
There's nothing wrong, but
And
you
we've been
Yeah.
respectful.
The
Hello,
thing is,
hello. Can I just say a
No.
contribution, guys? Colleagues,
hang on.
guys. I think Zukisa must go and listen to the recording. This thing is being blown out of proportion. The advocate was
Exactly, I
going
agree
well
with you
until he
100%.
started referring
She
to the
needs to
pages.
go
The
back
pages
and
are not
listen
the
to
same.
Exactly.
The pages
I
are not the
agree
same.
with you.
When the question was
I
asked,
think
I
the
was
best
also lost
solution,
where
the
we
best
are.
solution, let's give the school the
Yes, let's
chance.
go and listen, because to come and say we should be
Yeah,
prepared,
let's
whether you're
give
prepared or
the
not,
school the
is not the
opportunity to
issue here.
listen to the recording.
Yes, it's not the
When
issue.
they will
The issue,
realize that there was
the issue was
nothing,
that we were trying
you
to
know,
get
if they,
clarity. Where is the
if
professor?
they
Because
could
if you look at the
listen to
notes,
the recording,
it's not the
they
same
will
thing
find
as
a
what you were
solution.
saying. It's not
And
the same thing
another
what you was
thing,
talking about.
there's a bit of misconception because we were told that we are taking a break, but then it looks like there's no break.
No.
The lecture is being cancelled. So misrepresentation for me.
Guys,
Colleagues,
please, can I say something that will help us?
There was a misunderstanding. There
Can
was
I
a
say something that will
misunderstanding
help us?
from all of us. So that
Please,
misunderstanding led us to be in this situation. But it's not a bad situation if you are prepared to solve it on our own. There's nothing wrong if a person in a question, and there's nothing wrong if we ask a page number, but there was a confusion and we must accept and we must move on with the lectures. We
Zoe,
must not
yeah.
be
Must
angry.
tell us
But you
what to
cannot,
do now. What is the decision?
Guys,
This is
two
Lugisa.
wrongs don't make it right. Two wrongs don't make
Exactly.
it right. We are becoming wrong, and now the lecturer was wrong where he was wrong. Now everyone else is becoming wrong. Can we
We are
move
all
forward?
suffering at the
What's the solution? Because now we've been.
The solution
We
is
all
this.
gonna suffer. We're
We
gonna be
must
on the wrong side after all these recordings also.
guys,
But
please.
why did he
Let
say
one
he's
person
taking a
talk.
break? Why did he say
Come
that
on.
he's taking a break? And
We can't
only
even
to
give one
find out
person to
later
talk. We can't
that
even
the
Let me
lecture is
answer
being
one
that.
person a
cancelled.
chance to talk.
One of the things that we were
Can I-
taught that we need to be fit and proper person, and we need to be honest all the time.
No,
Remember,
let's not.
Can I respond to
practically
that?
or ethics.
Okay, guys, can we have one person talking?
Yes, can I
Let's
make a
not
suggestion here?
the problem. We must apologize and move on.
Exactly. Listen, guys, please. We are the people that our time are being wasted here. It is obvious that the advocate is not happy with the manner in which the whole thing is being conducted and the whole thing is being arranged. Listen.
Politics for what? We did nothing wrong.
Listen.
Yeah.
Please.
What
He raised this issue
progress
before.
Let's
He
apologize
made a
and move.
statement before that if we are not happy the way he's conducting the lecture, that we should refer to Zikiswa. There is a reason why he stated that. Now, going forward, we should have understood that obviously, probably he's not in the very good frame of his mind today. And we should understand human nature, understand how people behave and how their emotion plays out. We are not kids. So we are supposed to be patient.
It will scare you. I was
Going forward,
just
what we should
alarmed.
do is to appeal to Zukiswa to talk to him, to come back and lecture us. Because if we carry on like this, we are not going to complete the lecture.
Guys, this is embarrassing.
Okay.
We are very disorderly. We are very disorderly. We are not. Some people they speak forever. Some people speak forever.
Exactly.
Some people they don't.
People that want to speak alone, and other people
Yeah,
also,
some people
also have views. This
Okay, I've been trying to speak, so I cannot speak. I don't know how the poor advocate will come and address you. So I am ending this meeting. I'm ending this meeting now. You will think and sort yourselves out. I don't know. Please don't send me a lot of emails. I have this on record. Mr. Malema will sit with the advocate tomorrow, and then we will send an announcement on e-leader. He will not continue. Like you said, you don't want him, you want another lecturer, you have paid your
Madam
fees.
Zukis,
So I am
can I check?
ending this meeting.
I say something.
Okay, Madam Zukis, can I ask a question?
I know most of you have prepared for the lecture. I know that the people that have prepared are even quiet now, like wondering what is happening.
Yeah,
They-
Madam Zukis, can I ask a question?
Ma'am Zukiswa. Thank you, says Zukiswa. Let's meet tomorrow.
TV.
Colleagues,
Ma'am Zukiswa?
Yeah, please.
Hello, Ma'am Zukiswa.
I encourage him to come tomorrow. Please.
I want to appeal to you on behalf of the class now. Ma'am Zukiswa, if you are listening, please.
You can go.
I want you to speak to the advocate and tell him that probably we misunderstood him and we are sorry about the whole thing, that he should come back and continue the lecture tomorrow, please.
Yes. Seconded by me, please. Thanks. Thanks for that suggestion, my dear.
Thank you very much.
Full agreement.
Yes.
Humble. It won't be like to be humble. For once, let's just be humble and move forward.
Initially, we should humble ourselves. Thank you.
When
And
you
yes,
want to
I think
something from somebody, you